If you have a house inside one of these trusts, you can even sell your house and avoid paying capital gains tax on it, like you could have had you owned it yourself. Because a lot of people will say to me, well, gee, Bill, if I put this house into the trust and I can't change the trust, what happens if I want to move? What happens if I don't want to live in the house anymore? That could happen. Sure it could. And if that happens, the trustee will sell the house, get a bunch of money from the sale, and if you want to buy another house, you say to the trustee, well, I'd like to live in Florida now. Why don't you come with me, trustee? We'll go down to Florida together. We'll find a house. You buy the house with the money you just got from the sale of the other house, and I'll live in that house. That'd be cool. And the trustee can say, sure, let's go to Florida and look for a house. And you say, well, yeah, but if I'd owned the house, I could have sold it, and the tax code said I wouldn't have to pay capital gains on the sale. But now I don't own the house anymore. Does that mess that up? Answer, no. Not if you draft your trust right. Trustee can sell the house, and you can still get the tax benefit of avoiding capital gains on the sale of your house. You can take all that money and buy yourself a new house and live in that, and the trust owns the house. Or you can decide, I'm not going to buy a new house. I'm going to go move into an apartment. Well, the trustee sells your house, takes the money, puts it in the bank account in the name of the trust, invests it maybe, makes some dividends, makes some interest, sends you a check for the interest and dividends, keeps the rest of the money. When you need depends and you can't otherwise afford them, the trustee might be able to make the money available to do that. But the trustee is not going to go out and buy you depends. The trustee is going to take the money and give it to one of your other daughters besides Sarah, who's been written out. And say to her, you know, I can give you some money. The instructions I got from, Mom when she set this thing up said during her lifetime, if I wanted to give you some money, I could. You've been telling me you think your mother needs better incontinence products in the nursing home, so I'm thinking I should give you some money. Maybe you could take care of that problem. And so, trustee gives the money to the daughter. Daughter hops over to Target, buys the Depends, bops on over to the nursing home, drops a bag of Depends on your bed and says, there you go, Mom, you're all set. Now, did she have to do that? No. She could have taken the money and gone to Burger King, bought herself one of those new Jumbo sandwiches or whatever they're selling this week. She didn't have to do any of those things, but, and that's why I said, if you have a family that's not functioning very well and they don't get along very well, this idea may not work very well for you because it relies upon the strength of the family unit to honor a moral obligation which exists in the absence of a legal obligation. What are the disadvantages of setting one of these things up? There are always disadvantages. If anyone is telling you about any kind of planning technique, asset protection, estate planning, retirement planning, I don't care what kind of planning, if they're not telling you what the downside is, you're getting a sales pitch and you're not getting the full story. There's a downside to this. These trusts are irrevocable. You cannot rewrite them. You cannot revoke them. If they were a merry-go-round, you cannot just yell to the guy to stop the ride because you want to get off. It doesn't work that way. They can't work that way. If you had that much power, you wouldn't have protected your assets by putting them in the thing in the first place. So you need to build in flexibility to the document from the very beginning so that when things change, you have some opportunity to deal with that change. You may not have the opportunity to deal with every change in exactly the way you'd want, but you'll have some opportunities to deal with it. There's some uncertainty under the tax law about how these trusts are going to be handled in various areas, most significantly in basis adjustments on assets at death. I'm not going to necessarily bore you with what that really means, but essentially when people die owning an asset and they pass that asset on to their child, let's say, suppose it was a house. I bought a house in 1954. I spent $25,000 to get my house. I lived in the house until I died in 2014. The house at the time of my death was worth $125,000. I only paid $25,000 for it. Well, if I transfer that asset, if I give that asset, I should say, if I give that asset during my life to my child, their tax basis in that house is the $25,000 that I spent for it. And when they go to sell their vacation home in Moton, where I live, they will pay tax, capital gains tax, on $100,000 worth of gain. The difference between the value of the house and what I paid for it. $100,000 of capital gain is a roughly $20,000 kick in the shin for the kid. If they died, if I owned the house and I died and I transferred the house at death, well, the basis in the house gets adjusted from $25,000 up to $125,000. So now my kid can sell the house that they've inherited and they pay no capital gains tax. Well, there must be a catch. What is it? Well, they had to pay inheritance tax to get the house. They had to pay a 4.5% inheritance tax in Pennsylvania to inherit that house. And it was that payment of that tax that drove the basis up and allowed them to avoid a 20% capital gains tax. So when people come to me and say, I want to avoid the Pennsylvania inheritance tax, how can we plan to do that? I often have to tell them, oh, no. The inheritance tax is your friend. You don't mind paying 4.5% inheritance tax if it gets you out of paying a 20% tax. Pick your poison. It's the much lesser of the two evils. So when you put your house into one of these trusts, at your death, will you get a basis adjustment? The honest answer is probably, but we don't know for sure. It's kind of handled right now on a case-by-case basis. And because of that, we're hoping that we get a basis adjustment. This type of a trust does not do anything to reduce your inheritance tax liability. It will not reduce your federal estate tax liability, but the good news there is almost nobody has federal estate tax liability. Unless you happen to have more than $5.5 million, rounded, you're not going to have to pay federal estate tax at your death. So don't worry about the federal estate tax. But the Pennsylvania inheritance tax has no exemptions. They tax the first dollar and the last dollar and every dollar in between at a flat rate. For transfers to children, it's 4.5%. Transfers to siblings are 12%. Transfers to your friendly neighborhood attorney, 15%. So, these trusts are not utilized to avoid death taxes. They don't create additional death tax, but they don't reduce the death tax. We're simply not able to do everything. Save your money against nursing home care costs and save your money against various death taxes. The nursing home tax is effectively 100%. The inheritance tax is 4.5% most of the time. So really, I'd rather avoid the 100% nursing home tax than the 4.5% inheritance tax. So is it really a disadvantage? Well, it depends on it. What's the alternative? Well, I could just give the house to my kids. I don't have to have this goofy trust thing. Why would I like to do that? Well, if I transfer it to them, as long as I'm outside the Medicaid 5-year look-back, it's as effective at sheltering the assets as the trust would be. So in that sense, it's every bit as good as a trust. And it's simpler and easier to understand. I understand what it's like when I give somebody something. But there are some advantages and disadvantages to that. Well, what do we like about that idea? Well, it's simple. It's easy to understand. It's much less expensive to implement than setting up one of these convoluted trusts. But what don't I like about it? Well, I can't get any income off of the assets I've given to my children unless they decide to just give them to me. Maybe they will, maybe they won't. If I give the asset to my child and my child gets in trouble with a creditor, the child's creditors can seize my assets and take them away, and now I'm left without them. I didn't do anything wrong. I just happened to have a daughter who filed for bankruptcy, and suddenly I'm out. Maybe they got divorced. You know, maybe her husband, butthead, finally got kicked out. And he, through the divorce proceeding, was able to take part of the money you gave to your daughter to protect for you. So I'm not real wild about that. And of course, The more children I have, it only takes one of them to kind of screw up the whole plan. So I may have 3 children, and 2 of them may be perfectly nice, but one of them may turn out to be not so nice, or one of them may turn out to be very nice, but simply not a very good manager of funds. And they wind up getting themselves in financial trouble, and because I've tied my finances to theirs, I get dragged along through whatever mud they're going to go through. With a trust, you don't have any of those problems. Children's creditors can't attach the trust any more than your creditors can attach the trust. And so you're not dragged into all those kinds of problems. But you still are having to place some trust in them, in their behavior, the same way that you would have had you made an outright gift. And let's talk a little bit about why that is. I mentioned in passing, and I'll explain it now in a little bit more detail. With Medicaid, if you apply for Medicaid, they're going to ask you, have you made any gifts or transfers, sales of assets for less than fair market value? Have you done anything like that to make your assets less than they were afterwards? If the answer is yes, I've done that, and I've done it within 5 years of applying for Medicaid, their answer is no Medicaid for you. The more you've given away, the longer they're going to cut you off. But the 5 years is how far they look back in time from the day you apply and the day you've proven that you're sick enough and poor enough to qualify. They then look back in time 5 years and say, we want to see all your bank statements, all your brokerage statements, every financial asset that you have. We want to see all the statements for all those years, and we're going to look through them. And if we see any kind of a check going in or out for more than about $500, we're probably going to deny you Medicaid unless you can explain to us how that transaction was not really a gift. That's just the way Medicaid works. You're deemed to be ineligible until you can prove that you're eligible. So the only way you can prove you're eligible is to pony up all those records and let them go through everything and explain to their satisfaction why you're eligible. Why are they so mean to us? Why do they do that to us? Because it's their money. It's not our money. We're not entitled to this money. We have to earn it from them by following their rules. If we don't like their rules, we don't follow their rules, they don't punish us. They don't come after us. They don't take anything away from us. They just don't give us their money when we need it. It's kind of simple, really. So when you have these transfers within that 5-year period, you're going to be ineligible. Well, let's suppose that we have a house and we transfer it. We transfer it either to the trust, the Asset Protection Trust, or we transfer it to the kids. Doesn't matter which. And let's suppose on the day that we do that, we're alert, happy, healthy people. Just like you all are right now. And let's suppose that 3.5 years from now, we all collectively slip on the banana peel, fall, break our hip, wind up in the hospital. After our hip replacement surgery, we're transferred to the nursing home. After all the anesthesia and stuff we went through on the operating room, we're a little batty now. We don't think as clearly as we once did. And we're now being told, oh, too bad for you. You're going to have to go to a nursing home. It's not safe for you to be at home. You can't walk very well anymore. You're confused. You keep trying to answer the phone, but it turns out it was an iron and you've just burned the side of your face. And you've got all kinds of problems. You can't be left at home. Off to the nursing home with you. And you've got, $150,000 worth of savings. So you blow through that in a little over a year. Now you got no money. And you go to Medicaid. You say, look how poor and sick I am. And they say, well, we're hearing you so far, but have you given away anything in the last 5 years? And you say, well, 4.5 years ago, I transferred away my $210,000 house in Colony Park. Oh, they say. Well, the answer to you is, no, you can't have Medicaid. We don't know how you're going to pay the nursing home. We suggest you find the guy you gave that house to, and maybe he'll pay the bill for you. But we have no interest in helping you. And in fact, we're not going to be interested in helping you for quite a number of months going forward. And they'll tell you exactly how many days you have to wait before they're going to give you Medicaid. Which doesn't really mean much because if you're not paying the nursing home, they're going to want to be looking to get rid of you. So whether the penalty that Medicaid imposes on you for the gift is 5 months or 5 years, you're in a bad way because you need care. You can't get that care because no one's paying the nursing home, and the nursing home is not obligated to care for you for free. So, what could we do? I went to see this idiot lawyer. He told me about this stupid trust. He told me it'd be a great idea if I put my house in it. Then I slipped on the banana peel. I spent all my money. Well, this has brought me nothing but misery. I hate that guy. I wish I'd never done that. And now we are at the point where good planning parts from bad planning. Good planning is based on the idea that the plan will fail. It is not based on the idea that the plan will work. So, in a good plan, we've already thought about this contingency, and we've already developed an idea of how we're going to handle it. Well, what would be the easiest thing to do to cure our problem? We go to wherever the house is. I mean, it's literally physically where it always has been, but we go to whoever owns it, our trustee or our kid, and we say, who's usually the trustee is the kid, by the way, kid, things have not turned out as well as we hoped. We were kind of hoping we could get that house back. Because as it turns out, with Medicaid, if we get the house back, they'll forget about that whole penalty thing they were talking about because we gave it away. But we have to get back everything we gave them. If we gave away the entire house, we got to get back the entire house. If we gave away $100,000 in cash, we got to get back $100,000 in cash. Not 70, and they just shorten the penalty. You got to get back the whole 100, or the full penalty is in place. No partial cures. So, why do I bore you with this little story? Well, because of this little point right here. The more children that you give to, the greater the risk of these disadvantages. If I transferred the house into joint names with my 3 kids, and even one of them decides not to give it back to me, I'm done, even if the other 2 cooperate. If I have a trust, on the other hand, the trustee is going to be allowed to pick and choose among my children who to give the house to, because that kid, the cooperative one, is going to then give it back to me and cure the penalty. But if I have all the kids involved, I can't pick and choose among the bad ones and the good ones. Now, if I have only bad children, well, then I've got a problem. But I had a bigger problem anyway. You raised bad children. So, before I move on to family caregiver contracts, we'll kind of sum up the asset protection trust or the outright gift to children. I like the trust better for some of the reasons that I've talked about. You're taking assets, you're transferring them to the trust, you're giving up your right to ever get them back again, unless you get them back through the cooperation of your family. Those assets are ultimately, if you get past that 5-year period, which is why you need to do this when you're young and healthy, not when you're old and decrepit. You've got to transfer this before the need for care seems like it's even really much of an issue for you. Transfer those assets away, and they're available then for the family to collectively begin to use for your benefit. But they're not counted by Medicaid when you go in to apply because you don't have enough control over the assets in the trust to have Medicaid count them. Okay?